Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, another quick one before we get to some not quick ones is in Sacramento, where, look, this happened. It's unfortunate, but it happened in Sacramento. There's a settlement now where firefighter paramedics dropped when transferring an elderly person of 80 some odd years of age from chair to stretcher, dropped her, and I think suffered a left femur fracture. Unfortunately, that's not uncommon, right? Sometimes you get very brittle elderly people, calcium deficiencies, whatever. So I'm not saying a small error, but an error where they get, hurt is worse than it would be for a 20-year-old. Mm-hmm. So they settled this. $500,000 is a lot, frankly, in my opinion, except California has higher verdicts in some areas, and it's a high settlement number, but, it's painful. And here there was not just the wife, but there was what's called a loss of consortium, which means, okay, the wife did things for me as husband. The husband has had to incur costs because the wife isn't there to do these things. And so there's that. It's kind of an add-on, but it always accompanies husband and wife injuries like this. And they,
he's also alleged that zone of,
because he witnessed it.
Right.
In many states that would never survive. In any event, this wasn't a court case, it was a settlement. But I like what the city said. After a thorough evaluation, it was determined that settling this case was in the best interest of the city. And that's probably true, right? Because you don't know where it's going to turn out. You don't know what the damages would be. Why, that negligence, they may have been negligent, but, let's be clear. Somebody's saying, oh my God, dropping people is a real possibility. Well, listen, in a lot of places, dropping is negligent, right? And you are, as a firefighter paramedic, not a private industry paramedic, you would be protected from ordinary negligence. So I was surprised that they settled this with government immunities that would have forced them to say, look, you had to be careless. Now, I don't know whether they were or weren't. I have a hard time believing generally that paramedics would haphazardly, recklessly, dangerously transfer you, but things happen. But people shouldn't be afraid. Here's my point. I don't think people should be afraid that, oh my God, if we drop somebody, look, no one wants to drop anybody or hurt anybody, but normally this would never survive a motion to dismiss because it's accidental, right? It's not like they didn't attempt to be careful.
Yeah, I think that's a good point. And again, you shouldn't become paranoid about liability. There is plenty of immunity protection. There's a public duty doctrine. There's a bunch of different defenses that we typically have. Why they chose to settle this looks like, let's see, it was filed in April of 2022. So, about a year and a half. I would imagine that I didn't go back in the file and see if there had been a motion to dismiss. I would have thought, I agree with you. I would have thought this would have been wiped out with a motion to dismiss, but maybe there were some other factors. And taking a case to trial could be $100,000, $200,000 in legal fees and so on. So
right.
It is what it is.